Good? You got
Yep, I got you.
waist ahead, right?
Yep, I got you.
Right.
And your name is?
Sergeant Tate with
and
the
your
Sheriff's Office.
And your badge number?
31.
Okay.
You are being ordered out of a vehicle pursuant to case law, Brennan v. California, which gives us the authority from the Supreme Court of the United States to order passengers out of the vehicle.
And the Supreme Court has also ruled that we are able to travel unencumbered.
That's not true.
Yes, it is. The Supreme Court has ruled on that numerous times, the last time being 2014.
Okay. Ma'am, I'm trying to do this as safely and inconveniently for you as possible. So you have received a lawful order to exit the vehicle from one of my deputies. So
okay, why do I, if I'm...
You need to remove your safety restraint and you need to exit the vehicle.
Why do I need to exit the vehicle?
Ma'am?
Why?
Because he gave you a lawful order pursuant to case law that gives us that authority for our safety and your safety to step out of the vehicle.
You
I'm not
guys
get into semantics with you.
You
about
guys.
The argument.
Welcome back, everybody. As many of you guys know, I'm a law enforcement trainer instructor. I train and instruct military and law enforcement all over the country on various law enforcement disciplines to include constitutional law, case law, patrol tactics, use of force, advanced criminal investigations, etc. And we're going to be doing a quick video response to this sergeant, this SWAT certified sergeant, as it relates to ordering passengers out of the vehicle. So he did give a case law, Brennan v. California. Personally, I mean, the case law does make a nexus for talking about seized people. We'll kind of go over it, but overall, this is not the case law that I would have used or cited in this interaction. But he can cite whatever he wants. I will say I appreciate him for trying. But if I was to write this up and write a report on it, I wouldn't. That wouldn't be the case law that I would have cited for this particular incident. So the Supreme Court has made affirmations as it relates to removing people from vehicles. And so the first one that we all know about, most of us know, is Pennsylvania v. Mims, as you can see on your screen here. The Supreme Court has held that when an officer has made a lawful traffic stop, they may order the driver out of the vehicle for their own safety. During this lawful encounter, the officer may conduct a pat-down search if they reasonably believe the individual may be armed and dangerous. The court based this decision on the principle that the safety of both the officer and the public is paramount. The court noted that the intrusion of a pat-down search is minimal compared to the potential risks faced by law enforcement officers. And again, Pennsylvania v. Mims, 1977. So there is that one. Now let's talk about what he mentioned. He mentioned Brennan v. California, 2007. When a police make a traffic stop, a passenger in the car, like the driver, is seized for Fourth Amendment purposes, and so may challenge the stop's constitutionality. This is the one I would have used. Maryland v. Wilson, 1997. The United States Supreme Court affirmed that an officer making a traffic stop may order passengers to get out of the vehicle pending completion of the stop. The Supreme Court further affirmed that, as a practical matter, passengers are already stopped by virtue of the stop of the vehicle, so the additional intrusion upon them is minimal. So again, that's the one I would have used. Now, what we have to understand about Brennan v. California, pull this up again for you, as you can see here. What we really have to understand about Brennan v. California is the Supreme Court's making an affirmation here. The affirmation is essentially saying that passengers in the vehicle are seized, and because they are seized, they may challenge the constitutionality of the vehicle of the stop. So let me give you an example, right? So if I'm in a vehicle with my friend gets stopped because he's black, or let's say my friend gets stopped for no reason or articulable suspicion, right? Driving while black, or he's just driving in a neighborhood and the cop doesn't know who he is, whatever. Let's just say there's no reason or articulable suspicion as required by United States v. Cortez. And so me and my friend are in this vehicle, are stopped unconstitutionally. Well, if my buddy is like, hey man, I don't want to make a big deal about it, we didn't get a ticket, oh well, right? He's 100% within his rights to be like, you know what, I don't want to make this a bigger deal. But as a passenger, I still have the right, pursuant to Brennan v. California 2007, to say, well, no, this wasn't right, and I have a stake in this because I was also seized, right? So a traffic stop is a seizure of all occupants. So I want to challenge the constitutionality of the stop. Just because my friend doesn't want to challenge the constitutionality of the stop is of no consequence to me. right? Because now the police can't say, well, this is business between me and him. Well, no, because you have seized me in this traffic stop. I am now seized. I am not free to go. So I am every bit a part of this traffic stop as well. And so that's what Brenlin v. California really does as far as case law goes. But I mean, it is good in stating that there is a seizure. And again, Maryland versus Wilson further expands on the Pennsylvania v. Mims ruling that the seizure also allows. So the seizure also means that the officer can remove you from the vehicle on a lawful traffic stop. So that's the case law I would have used. It's more applicable than Brenlin v. California, but again, the sergeant was probably in the heat of the moment. It was probably, the first thing that came to his mind in relation to traffic stop. So that's why he probably used it. Now, this other lady, whoever he was talking to, is making mention of their Supreme Court case precedents out of 2014 that says that drivers can drive unencumbered. I have no idea what that is. If you guys know what that is, leave in the comment section below. I don't know of any. Driving in general requires, for example, states require you to have insurance and registration. So that would be an encumbering element in and of itself. So this idea that the Supreme Court stated that, again, there's no case law that I'm aware of that says that you can drive unencumbered with no restrictions whatsoever. It's just, again, there's plenty of Supreme Court case law that actually says against that. So again, just something to think about. People like to spit case law like they know it. Like this woman here, she obviously doesn't know it. This sergeant attempted to, explain why he was doing it, and yes, Supreme Court case precedence does allow him to do that. I just would have went with a better Supreme Court case precedence. I would have went with Maryland v. Wilson, 1997. So there you have it. There you go. If you have any questions, please leave in the comment section below. Tell me what you think about this. Tell me what you think. Do you think that the Supreme Court got it wrong in all three of these case laws? Do you think they got it right? How do you think the officer should have handled it? Curious to know what you have to say in the comment section below. As always, guys, long live the Republic.